We should officially begin now. I'm Margaret Jackson, and I'm the co-director of the Frida Center. And along with the other co-director, Sarah Yursich, we're going to be coordinating the Act to Action webinar today. And we've both been looking forward to this webinar for some time, so it's great that we're actually moving on to this. And the title of the webinar is Improving Access to Justice Through Safeguards in Parenting Assessments. But before I introduce the speakers and the topic more fully, I would like to provide the SFU land acknowledgement. So the Frida Center respectfully acknowledges the Musqueam, Squamish, Tsleil-Waututh, Cotsee, Quick-Wet'lem, Kwetlen, Semiahmoo, and Tsawwassen peoples on whose unceded traditional territories Simon Fraser University's 3 campuses reside. So first, background. So today's webinar is based upon the report titled with the same name on parenting assessments in BC, published by the Rise Women's Legal Center. And parenting assessments in BC are often ordered when there are court proceedings about parenting issues to provide evidence to the court about the views and needs of the children and the ability and willingness of each parent to meet these needs. That's why we're most fortunate today to have with us the report's 2 co-authors, Gina Addario-Berry and Magal Huberman, to discuss their findings and their recommendations on this very important topic. But first, I want to give some information about the speakers themselves. The first presenter is Magal Huberman, and she is a family law lawyer and family mediator in Vancouver. In addition to her private practice, Magal is a supervising lawyer at the Everyone Legal Clinic, where she supervises articling students in family law matters. And her volunteer work includes pro bono services as a family lawyer and family mediator at Access Pro Bono Society of BC, pro bono legal services at Rise Women's Legal Center, and volunteering at the Trial Lawyers Association of BC as co-chair of the Family Law Committee. And Magal also publishes and presents on various family law topics. For our second presenter, Gina Addario-Berry is a Vancouver-based lawyer practicing primarily in the social justice sector to support survivors of violence. And she has managed various projects in research and address systemic legal issues, designed legal resources and training programs for frontline workers, and drafted law reform recommendations. And she is currently representing and advising children and youth involved in family law proceedings in British Columbia. So I will turn it over now to Magal. And I just should also remind you quickly that both presentations will be made before the questions and discussions. So as we proceed, if you have questions, as Sarah mentioned, please do enter them into the Q&A box instead of the chat. All right, over to you, Magal. Welcome. Thank you.
Thank you. All right. Good morning or good afternoon, everyone. Welcome to the webinar, and thank you so much for attending. Thank you as well to Frida for inviting Gina and me to speak about our report, and thank you to all the organizers of the webinar. We published the report in February 2024. We worked on it for quite a long time during 2023. But this is actually the first time that we get to actually talk about it. So far, obviously, we've been discussing it between ourselves and with our colleagues at Rise Women's Legal Center. But this is really the first opportunity that we have to present our findings to such a large group. So we're very grateful, very excited, probably a touch nervous, but very, very excited to be here. And thank you again for the invitation. I'm just to coordinate the slides. Jade, I'm at the what we will cover today slide. So I hope that everyone is seeing that slide, what we will cover today. The report is a bit too long to cover fully in this webinar, but what we hope to provide today is some highlights of the report, and we hope that you will leave this webinar with a better understanding of what we try to do in the report and how the report can potentially be useful for your own work. I know that there's people here from various backgrounds and various disciplines and professions. So among you, different ones will probably find different things that could be useful in the report, hopefully. So what we will cover today, we'll start with an introduction that I'll do, which will be an overview of the legal framework for expert evidence, just so that we're a bit on the same page about that, particularly because both Gina and I are lawyers, so we approach this from a legal perspective. We'll provide a brief overview of parenting assessments in British Columbia, typically called Section 211 reports. And we'll also provide a very, very short, just a few points about research about parenting assessments. Then Gina will provide an introduction specifically to our report, basically what our process was and what to expect in the report. And then we'll delve into our recommendations. And as you'll hear, our recommendations and findings are discussed in four themes. The first one is assessors training and experience. The second one is practice standards for reports. The third is financial barriers. And the fourth is judicial gatekeeping and oversight. And then we'll move on to a summary and of course a Q&A, which we look forward to. So just to get started with an overview of the legal perspective on parenting assessments, and I'll just be referring interchangeably to parenting assessments and Section 211 reports, as they're called in BC. So parenting assessments or Section 211 reports are a type of expert evidence. What is expert evidence? So generally, witnesses in court can testify about facts based on their personal experiences. However, expert evidence is an exception to this general rule in that experts can provide an opinion. For example, they can provide an opinion in the form of a medical diagnosis. If we're talking about financial issues, they can provide an opinion about the value of an asset. Or in the context of parenting assessments, an example of an opinion that the expert can provide is an opinion about parenting capacity. Next slide, please. So some rules and restrictions on expert evidence. So generally and historically, courts treat expert evidence cautiously. And the reason for that is that judges are the ones who have to make findings of facts, basically determine what happened, who to believe, and judges are the ones who are supposed to make decisions and orders. However, their training and professional experience are in the legal domain. And if the issues in court require specialized evidence that someone who is trained in the legal domain would not typically have, then having expert evidence can make sense because it can fill gaps in the evidence that the judge would otherwise not have. So that's really the general benefit of having expert evidence. On the other hand, the courts have recognized that there is a risk in introducing expert evidence because the expert's credentials, so experts would typically have higher level education, like a PhD, for example. They would also have experience and expertise in a complicated subject matter that's outside of the judge's expertise. So there is a concern and a risk that because of the expert's credentials and the specialized and complicated subject matter, their evidence would be accepted without sufficient scrutiny. So essentially, expert evidence will basically determine the outcome of the case rather than the judge or the court, as it's meant to be. So to protect against that risk, Canadian courts have come up and developed some rules about the admissibility of expert evidence. So by admissibility, I mean, when will expert evidence be allowed to be presented in court? So the rules and restrictions have developed mostly in two Supreme Court of Canada cases, R and Mohan, and the other one is called White Burgess. And the rules are, so first of all, before admitting expert evidence, the court must consider whether the expert evidence would be relevant, whether it is necessary. So basically, whether without the expert evidence, there would be gap in the evidence that would hinder the ability of the court to resolve the issue. Whether there are any other rules that would exclude the expert evidence, and whether the expert is properly qualified. Because of course, if we're talking about a complicated subject matter, a specialized one, then we need to make sure that the person who's giving an opinion about it is actually properly qualified. Even when these four conditions are met, the court can still exclude expert evidence based on a cost-benefit analysis. So basically, whether the risk of having the expert evidence in outweighs the potential benefits. In addition, the expert has a duty to the court to be fair, objective, and non-partisan. So basically, even if the expert was hired by one of the parties, they still have to provide their evidence in a non-partisan way, so not favor the party who retained them. And the expert's opinion must be independent, impartial, and unbiased. Now, just as a brief disclaimer, this is a very high-level overview about the law about expert evidence. There's lots and lots of cases and lots of writing about it, but this is just to provide a bit of orientation before we begin to talk about how Section 211 reports fit within this general context on expert evidence. At the end of the day, the judge must be satisfied that the potential helpfulness of the evidence is not outweighed by the risk of the dangers materializing that are associated with expert evidence. Next slide, please. So what I talked about in the previous slides were the general rules that apply to expert evidence, but how do these rules apply in Section 211 reports in British Columbia? So at a high level, the rules apply. So basically, relevance, necessity, etc., absence of an exclusionary rule, cost benefit. However, in practice, Section 211 reports, unlike other types of expert evidence, are routinely admitted into evidence without going through the whole process and examination and scrutiny that I've just described. It would actually be very unusual to exclude them from the evidence. Instead, if there is, for example, a party disagrees with conclusions or recommendations or other statements in the report, if there's a challenge to the report, then it would be about the weight to be given to the report, or whether the expert's recommendations or opinions should be accepted or rejected by the court. But the report would normally be part of the evidence without going through this whole process of admissibility that I described in the previous slide. The main reason for that is that the author of the Section 211 report is appointed by the court. They are the expert of the court rather than of a party or parties. And then for this reason, courts tend to assume that they are, as required, impartial, independent, unbiased. And one of the main issues that prior critiques of Section 211 reports have raised, and that our report talks about as well, is whether these assumptions are actually warranted and whether we actually need additional safeguards in place so that reports, Section 211 reports, are indeed independent, unbiased, impartial, and of high quality. Next slide, please. So I'll move to talk a little bit about the legal framework around Section 211 reports. The primary legislation that governs Section 211 reports in British Columbia is, unsurprisingly, Section 211 of the Family Law Act, which is provincial legislation in BC that deals with basically almost all the issues that may arise from separation. So like parenting arrangements, financial issues, etc. I've copied here just subsection 1, but I'll give a brief overview of the remaining sections. It's not a long section. And what it says essentially is that a court may appoint a person to assess for the purposes of a proceeding that deals with care of and time with children, one or more of the following: the needs of a child in relation to a family law dispute, the views of the child in relation to a family law dispute, and the ability and willingness of a party to a family law dispute to satisfy the needs of the child. So this is like the primary statement that we have about what parenting assessments in BC are supposed to do. In terms of who can prepare them, so Section 211 reports, Section 211 of the FLA states that the assessor must be a family justice counselor, a social worker, or another person approved by the court. And I put in the example of a registered psychologist who very often prepare reports, particularly when the assessor is privately retained as opposed to a publicly funded assessor. Family justice counselors are, on the other hand, are publicly funded. So they would be selected, they're employees of court services in BC. In addition to this part that I've copied here on the slide, Section 211 report also talks about the parties sharing the cost of the report and a few other issues. But this is really the primary legislation that we have about Section 211 reports. So even though Section 211 reports in BC carry very significant weight in court, the rules that govern them are actually relatively minimal and also to some extent inconsistent, as we'll talk about in the next slide. So next slide, please. So in addition to this primary legislation that we have, Section 211 of the FLA, Section 211 reports are also governed to some extent by the rules of court. So in British Columbia, we have 2 levels of trial courts that can deal with parenting issues, the Provincial Court and the Supreme Court. Each of them has its own set of rules. In addition, the governing bodies of the assessor, so for example, if we're talking about registered psychologists, then you have the College of Psychologists of BC. If we're talking about social workers who also prepare Section 211 reports, then we have their college. So these governing bodies each have different guidelines, checklists, codes, etc. But each of them is a bit, I think we would say, siloed in that they're not necessarily similar. The level of detail of the rules is not necessarily similar. And we also found a bit of a disconnect between what the rules are for the governing bodies and what rules and the rules of court and basically the approach of the courts to these reports. There are also non-binding standards. The Association of Family and Conciliation Courts have published an initial set of standards for parenting assessments, and a few years ago published an updated version of that. These are very useful and definitely a very good reference, but they're not binding unless they're made into legislation, unless they're basically adopted into legislation, which in BC they're not. One potential change that could be coming up is the BC Attorney General's Family Law Act Modernization Project. So this is a project that started a few years ago where the Attorney General has been going through the Family Law Act and doing public consultations and amendments to the Family Law Act. We're now in the midst of phase 2. Which is very large. It deals with essentially all parenting issues. So it covers quite a lot. One of the issues that it covers is parenting assessments. And I put in the link. You can read, I think that the report, so basically what they've done so far is a very extensive public consultation, consulting with advisory groups, and publishing a paper with all the feedback that they've received. This is, I think it's a really good read, and it includes a whole chapter actually about expert reports and Section 211 reports. Now, in addition to the issue that we have in terms of fairly minimal safeguards and inconsistencies, we also have an additional practical challenge in BC, which from what we have read and having discussions with people in other jurisdictions is quite a widespread issue, not just a BC one, is that there's a fairly small number of assessors, which makes which raises a bunch of issues, both in terms of training, in terms of experience, and in terms of wait times and potentially costs. So just to keep in mind that in addition to the legislative framework that we have quite a lot of recommendations about in the report, we also have some practical challenges, which definitely include the relatively small number of assessors. Next slide, please. So in BC, the typical process for a Section 211 report, which I think is also a typical process in various other jurisdictions, is to have at least one and typically two interviews with each parent. Often, I mean, depending on what the professional designation of the assessor is, but registered psychologists, for example, will typically administer some psychological testing, which Gina will talk about. They would also typically observe each parent with the child or the children, speak with the children, obviously depending on the children's age, interview collaterals, so to speak with other people who may have some important information about the parents or the children or the family as a whole. So that could be friends, family members, teachers, healthcare professionals, etc. Review documents, so that could be court documents, it could be other documents as well. And at the end of the day, as required by Section 211 of the FLA, provide a written report that sets out the information collected, analysis and recommendations. The report is filed with the court and provided to the parties and to their lawyers. And based on our literature review and the interviews that we did with various lawyers and others, in each of those steps, various problems and concerns can arise, which we'll talk about more in detail as we go through our different themes and recommendations. So my last slide for the introduction before turning it over to Gina is just a few quick comments about research about parenting assessments. And when I talk about research about parenting assessments, I mean not just in BC or in Canada, but in other jurisdictions as well. So as part of our report, we did a literature review. We found quite a lot of literature coming out of the US. There's also from Australia, from New Zealand, and from Canada as well. Definitely, research about parenting assessments has been significantly increasing in the last few details. So there's definitely more and more of it, and it deals with various issues. And it can be about best practice. So just to give very few examples of what the research is about, best practices, uses of reports. So basically, their use in court, their use in out-of-court resolution like mediation. Views about reports. So, for example, how do judges view them? How do lawyers view them? How do the assessors themselves view the reports and their quality? And certainly a lot of research and literature about concerns and problems with parenting assessments. I would like to highlight two important gaps that we found in our literature review. So, first of all, we found no studies that have evaluated how children and families fared when the recommendations of a report were implemented compared to how they fared when the recommendations were not implemented. And we also found no studies that compared outcomes for children and families when recommendations were implemented, no implemented, or when there was no report at all. And this is, sorry, I heard someone speak.
I think we need the next slide up for this content.
Oh, I'm so sorry. Yes, so next slide. Sorry. Thanks, Gina. So I'm in the slide titled Research about Parenting Assessments. So as I've just said, research has been significantly increasing. I gave just a few examples of the many issues that the literature about parenting assessments covers. And I just moved on to talking about two important gaps. So the first one is there are no studies that we found that evaluated how basically what the outcomes were for children and families when recommendations were implemented or not implemented, or there were no reports at all. Now, the reasons for this gap could be and likely are that there are significant challenges to conducting empirical longitudinal studies. So there's challenges of funding, confidentiality, recruiting people to participate, and attrition. However, because the purpose of Section 211 reports or parenting assessments is to help determine and advance the best interests of the children, it is a fundamental gap. It's concerning that we don't actually know whether and to what extent and when these reports actually result in better outcomes for children. The second gap that we found is that research about report quality is limited. And there's just to highlight a couple of things about that. First of all, there might be some disagreements about how to define a high quality report. Like, do we actually have universal standards for that or agreed upon standards about that? And then the second thing is that most studies about the quality of the report are based on surveys. So basically asking judges, asking lawyers, asking assessors to evaluate the quality of reports, as opposed to the researchers themselves having a good sample of reports and being able to read them and analyze them and evaluate them. Surveys, according to the literature, are less reliable precisely because the researchers cannot do an independent evaluation. So both of these gaps are concerning because the outcome of the reports can have profound and potentially adverse effects on families, in particular on the safety, security, and well-being of children. So with this, I will turn it over to Gina to talk about our report and what we did.
Next slide, please. Thank you. Thanks so much, Magal. So thanks again to Margaret and everyone at FREDA for having us today. My name is Gina, and I'll be talking a bit more about the report preparation process. As mentioned, this project, which was funded by the Law Foundation of BC and produced by Rise Women's Legal Centre, sought primarily to identify options, concrete legal mechanisms by which we could create safeguards and to take the information that we gathered together to make recommendations to the Ministry of Attorney General, which, as Magal mentioned, was and continues to undertake a modernization of the provincial family law legislation, the Family Law Act of BC. And to contextualize our research project, given that there's no specific court rules or requirements on an appropriate procedure for writing a Section 211 report in BC, neither a timeline for preparing a report or on the content of a report, we wanted to try to look into a potential regulatory framework, and we looked to other jurisdictions outside of BC to gather insight into what a more robust legal framework could be. So part of the process and our initial steps were to do a literature review about both 211 reports and similar reports in other jurisdictions. We also reached out for interviews through an international listserv of family law practitioners, and we consulted a committee, which was an advisory committee for our project, and we brainstormed with them about themes, topics, questions, and concerns around family law and the parenting assessment context, and we identified potential key informants for discussion. From there, we created a list of legal experts and other interdisciplinary experts to reach out to in BC and other parts of the world. As Magal mentioned, we spoke to professionals in the US, in Australia, in New Zealand, as well as in countries in Europe. And at this time, I was also coordinating and organizing a series of focus groups for women throughout British Columbia, in both urban and remote communities who had experienced intimate partner violence. And I was seeking their input on their interactions with the family court system to find out what areas of the court system need improvement for survivors of violence. This was a separate but related project, and it provided me with a double opportunity to also hear the women's impressions about 211 reports, how the assessors had treated them, whether they had addressed concerns in a trauma-informed manner, and whether they could handle complex family violence, and also whether they encountered any financial or other barriers along the way. So Magal and I split up conducting interviews. We spoke with informants who were lawyers, psychologists, clinical counselors, legal academics, and retired judges. That's aside from the court users who I interviewed through the focus groups. And then we analyzed all of the responses and the transcripts from our interviews in order to identify the overarching themes. And we narrowed those themes down into the 4 which we will be focusing on today in the rest of our presentation. Next slide, please. And I'm going to pass it back to Magal here.
Thank you. So I'm at the slide titled Themes. So we identified 4 broad, but importantly, interrelated themes. So obviously we broke it down by themes and then like sub-themes and etc. But it's important to keep in mind as we go through the themes and our recommendations in more detail, that the themes are interrelated and that each of them might affect the other in various ways. So the themes that, as I've said, are assessors' training and experience, practice standards, both for the process of preparing both for the assessment process and for the report content, financial barriers, and judicial keeping and oversight. Next slide, please. So I'll start with theme 1, which is about assessors' training and experience. So just to explain like how we prepared these slides. So in preparing these slides and preparing our presentation, we basically combined together what we found in literature reviews and in the interviews that we conducted with various professionals and focus groups. But for I guess for a more detailed of what exactly the literature review said, like for particular comments, please refer to our report. What we provide here is kind of like a summary. So there seems to be, when it comes to training and experience, there seems to be a consensus that assessors must have high quality and comprehensive education and training. In BC, however, we don't have uniform training requirements. And another issue is that based on international surveys of assessors, that's in the literature, indicate that the process of becoming an assessor is a bit murky in the sense that there's no clear path to becoming a forensic assessor. So for example, things like graduate courses, internships, they infrequently focus on forensic evaluations. And based on the literature review that we did, only about 1/3 of assessors took graduate level courses on these topics, and even less received training on them during an internship. And this is important because a forensic role is very different from a clinical role, which many graduate programs focus on. So in terms of our recommendations, we recommend mandatory and evaluation-specific training and experience requirements that would apply to all evaluators of any professional designation. So essentially bringing this consistency. We also recommend both foundational or initial training and ongoing annual training, basically to keep things fresh and updated, and that evaluators would actually need to show completion and currency of training requirements before they are appointed to prepare an assessment. We also recommended that training would be approved by a single body. We gave the example of the Attorney General, but there could be other options as well. But the thrust of all of this is to ensure, first of all, quality and consistency and currency in training. Next slide, please. So in the next couple of slides, I have some examples of what we got in terms of feedback about the issues that particularly warrant specialized training. There are additional topics that are all listed in our report, but just to give a few examples. So one very big one that repeatedly came up both in the literature and in their interviews is the lack of and the need for specialized training in family violence and risk management. So I gave a very few examples of what that could look like. So this is by no means a comprehensive list, but it would include all aspects and forms of family violence, including coercive control, the impact of IPV on children, its impact on parenting, appropriate evidence-based services for survivors and perpetrators of family violence. So these are repeated themes, and including that training must be comprehensive. It must be ongoing as our understanding of family violence and risk evolves. Another thing that came up is not to assume that having any specific professional designation means that the assessor actually understands family violence or abuse or their impact. So just having the professional designation of, let's say, for example, social worker or registered psychologist, which are obviously important and carry a lot of training, but they don't necessarily automatically mean that the professional has this specialized training in family violence and risk. Another issue that came up is all the different non-physical types of family violence and abuse, and the very important need for specialized training and understanding of them. So things like just the impact of fear, the impact of stress, even when there's no recent incident of physical violence, understanding what abuse actually looks like and the types of abuse. So what we see very often in family law cases is financial abuse. We see litigation abuse. We see repeated unfounded complaints, for example, to schools, to child protection, against the parent who's been experiencing abuse. We see undermining and even sabotaging the other parent. We see things like interfering with the children's lives in terms of interfering with their schooling, with their activities, with their medical care, etc. So all of these things are obviously things that are, you don't see any bruises, there will not be any hospital reports, but these cause significant damage. But we need specialized training for the assessor to understand them, see them, look for them, and understand what their impact is. Next slide, please. Some additional topics that came up as important for initial and ongoing training is child development and capacity, importantly, skills for interviewing children and understanding the impact of the evaluation process and the report on the child. And this is important not just as a theory, but also practical, keeping in mind what are some best practices when meeting and interviewing with children. Also keeping in mind the impact of any family violence on what the child might say, how the child might present, how they might behave with each parent in the observation of the child and the parent together. All of these things can actually appear counterintuitive if the assessor is not familiar with the impact of family violence and its impact on children. Another topic that came up is fundamentals and foundations of family law, because there seems to be quite a frustration on the part of lawyers in BC, at least those that we interviewed, in terms of assessors not really understanding or knowing what the judge will consider, and also understanding what recommendations are actually practical in the context of family law. So as Gina will talk about when she talks about financial barriers, Section 211 reports are expensive. They're also a stressful process to go through. So just imagine the frustration of spending a lot of money going through a difficult process, but ending up with an analysis and recommendations that really are not practical from a family law perspective, where the issues are going to be resolved. The other issues that came up are cultural humility in general, and also a very important issue that came up repeatedly was an Indigenous lens to interpret and identify the best interests of Indigenous children and families. And in this context, there was a particular note about paying attention to specific communities within Indigenous people, specific communities, specific nations. So having this understanding of the specific issues that might affect a child and a family from a specific community or nation. Next slide, please. So in addition to the standardized mandatory training, we also recommend, and this is going to experience, we recommend exploring possibilities for new or newer evaluators to shadow and co-work with more experienced and qualified evaluators before they do their own assessments. Again, this is a very complex and specialized area. So these opportunities for peer supervision, for shadowing, co-working can really make a difference. And also having some work experience requirements that are relevant to evaluations. For example, working with children and adults who are impacted by family violence and IPV. Another issue that came up was the need for specific expertise. So, for example, let's say that a child in a case has autism. Expertise should be beyond what the standardized mandatory training would be, and has to be proven beyond just the assessor stating that they've taken, let's say, a course or two, or have some sporadic experience or interest in the area. So again, going back to the requirements that I've talked about initially today, which is a properly qualified expert. We definitely recommend, and I'll talk about this in more detail later on, judicial oversight to ensure that prospective evaluators meet the training and experience requirements, including any assessment-specific expertise, and exploring the possibility of having a publicly available list of evaluators who have the required training and experience. So the basic one and annual training. Currently, we don't have that. So there's definitely a word of mouth thing. There's basically, there's, like I've said, a small number of assessors, but there's nothing like a list, an accessible list where people can actually go and see who can do what. Another recommendation that came up from our interviews is to enhance training for judges. And this is about social sciences and about parenting assessments. And this is basically to enable them to better apply judicial scrutiny to the evidence, to the expert evidence, and better identify any flaws and limitations. And this is both for judges and should be for lawyers as well. So to summarize this theme before turning it over to Gina to talk about our second and third theme, training for assessors should be a broad and dynamic process that includes not only initial education, but also ongoing training throughout the evaluator's career. And in addition, evaluators should be aware of the limitations of their skills and refer matters that are outside of their expertise to appropriate specialists. And I'll turn it over to Gina.
Thank you. Next slide, please. So I'm going to talk about our second theme of recommendation, which pertains to practice standards for Section 211 reports. Now, it's uncontroversial that practice standards are necessary in this area, but concrete guidance is sparse, and as Magal mentioned, it's non-binding at this point. Family law court decisions out of BC do provide some guidance. For example, I'm going to quote from the decision of Dowell versus Hamper, which states that the court rightly expects that in addition to complying with the assessment and reporting standards prescribed by, in this case, the College of Psychologists of BC, when preparing a 211 report, any registered psychologist will also read the background material provided by the court or counsel, including affidavits, prior assessments, medical or other expert reports respecting the parties or the children. Be thoroughly conversant with current assessment standards and procedures, as well as up-to-date social science respecting parenting practices following separation and divorce that best promote and protect the child's long-term psychological and emotional well-being. Produce a well-written, well-organized report with appropriate headings and subheadings supported by a detailed table of contents. Set out discrete and separate assessments for each assigned inquiry. For example, the views of the child, the needs of the child in the context of parenting disruption arising from the family law dispute, and the ability and willingness of each parent to meet those needs, and to make recommendations respecting the future parenting of the child, supported by a detailed explanation of why and how those recommendations would promote or protect the best interests of the child, with reference to any appropriate current social science. As well as the case law that we can gather insight from, the Supreme Court family rules also provide that an expert must not be an advocate for any party, similar to the civil rules of court, but enforcement of this can be complex and challenging. And a common theme of feedback from our informants, which Magal also mentioned, pertains to practice standards for managing family violence. So We recommend routine screening for family violence and a fulsome analysis of family violence and its impact. We also wanted to emphasize that it's the role of report writers to educate the court on family violence, and that can often be ignored or glossed over from what we've seen. More protective measures are needed to ensure that individuals, and particularly children, will feel safe in disclosing violence to assessors without fearing repercussions from the other parties for doing so. One of the informants who we interviewed also stressed the importance of having a balanced process insofar as the assessor should interview collaterals on both sides of the dispute rather than only one side, and to question the statements of each rather than assuming credibility from one parent or one parent's collaterals over the others. And we also heard from our informants the importance of limiting the scope of recommendations in a 211 report to the topics which are directly within the evaluator's area of expertise. This is also just consistent with the way that expert evidence is treated in court in generally, and when an expert tries to give opinion outside of their expertise, it's objectionable. We also wanted to improve standards to mitigate and guard against biases. And this connects with a need to increase the diversity in the pool of report writers in order that those who are writing these influential reports have a deep understanding of the dynamics of the people and their diverse lived experience, as well as non-Eurocentric cultural backgrounds and family systems. One of our informants commented that psychometric testing, which I'll get into a little later, is often based on Western concepts of development, child development, families, relationships, and individualization, whereas in other cultural communities, we might look at working collectively, holistically, and through intergenerational knowledge. Next slide, please. So one of the challenges for implementing universal standards is that each assessor has their own professional governing body depending on their training. So they have their own sort of regulators to account to, who might have their own sets of rules and policies, and this can undermine consistency in the approach to writing parenting assessments. An Australian study from 2021 that we looked at as part of our literature review, which was published in the Journal of Family Trauma, Child Custody, and Child Development, explored what constitutes a high-quality child custody evaluation. And this study concluded, based on interviews with judges, lawyers, and evaluators, that high-quality reports are thorough, transparent, provide a path forward, and assist the parties of the litigation, their lawyers, as well as the court. So to break this down a little further, the thoroughness component related to investigation, analysis, observations, and explanations of family dynamics. Transparency relates to explaining the evaluator's methodology clearly, their reasoning and opinions, and also to consider alternate hypotheses and acknowledging limitations. So you can see on this slide, we've recommended acknowledging limitations in a report and also including any information or research that does not support the recommendations made. A path forward relates to addressing the referral questions posed by the judge to the assessor and considering possible outcomes and risks and providing clear and specific recommendations to help move the case forward in the proceedings. So the recommendations from this study provide some structure which could be useful in designing practice standards for 211 reports in BC or other parts of Canada. Another consideration with practice standards is the disclosure and management of sensitive information. Often through the 211 evaluation process, assessors obtain access to personal health information related to the parties and the children. And while some professional bodies may have clear rules around how that information should be used and retained, others may not. It would benefit litigants in family law proceedings to know how their personal information will be handled, whether it will be retained or destroyed, and within what timeframe after a proceeding is concluded. Next slide, please. So regarding psychometric testing, whether or not psychometric testing is useful or appropriate was another controversial subject that we looked into through our interviews and research. Some of the concerns about testing relate to indiscriminate use that unnecessarily increases the costs of reports. Psychometric testing would obviously come up more in the privately retained evaluator process as opposed to the reports prepared by family justice counselors. So another issue with these psychological assessments is the assessors are not required to disclose the data that they gather and which forms the basis for the conclusions of their testing and analysis. This connects clearly with the prior theme of transparency, which is important in these evaluations. And particularly when it comes to cases with family violence, a concern was that sometimes the after effects of abuse can be considered indicative of a mental disorder when a survivor of violence is put through a psychological evaluation. So a forensic nurse who we interviewed noted that sleep is one of the biggest things that's interrupted for people who've experienced any form of trauma. And it's one of the things that is often missed in medical follow-up and assessment. So with sleep disturbance, memory issues can be a part of that. There's going to be an inability to stay focused and concentrate on things. And a survivor of family violence with lingering trauma may not be able to present the best version of themselves in a psychological evaluation process, even though they may have the long-term ability to provide a safe and stable home if treatment and safety measures against further family violence are put into place. It's important to note that no psychological test has been validated for its predictive reliability for outcomes in child-related disputes. And a clinical counselor who we interviewed recommended that reports which use psychological testing should include up-to-date valid research showing why the tests they're intended, why the tests that the assessors are intending to use are relevant to the assessments, and to exercise caution around using tests which are known to have gender biases. So as we've noted in our slides, we recommend standards on when testing is appropriate or inappropriate, how the test results may or may not be used, and also mandatory disclosure about populations that the test was standardized on, limitations, and the specific purpose of using any given test. Next slide, please. So I'm going to move along to the third theme in our report, which relates to financial barriers. As Magal noted earlier, there are sort of two streams of 211 reports. The ones which are prepared by family justice counselors through the court services are free of charge. The ones that are prepared by clinical counselors, psychologists, and other professionals are at the cost of the parties themselves. And particularly for individuals who live in remote communities, it can be financially prohibitive to obtain assessments, because aside from the fees for getting the evaluation conducted, they also have to bear the cost of the travel expenses of the assessors. In cases where there's a financial imbalance between the parties, shouldering the cost of even half of a 211 report can cause financial instability, and this can jeopardize one parent's ability to provide for the child's basic needs. In many cases, this disproportionately negatively impacts women. Challenging reports which have been issued is also an obstacle, because typically the only way to do so is calling the author of the report to testify in court for cross-examination, and calling an expert witness to court is very expensive. It also necessitates a trial, whereas often an out-of-court settlement resolution can be a more cost-effective approach to resolving differences. So some ideas we came up for our recommendations in the area of financial barriers came from looking to other jurisdictions which have addressed financial barriers in parenting reports in innovative ways. So in Ohio, in the States, the court rules allow the court to allocate the expenses of a report according to the respective financial means of the party. And the court rules require that the court determine their ability to pay in advance of ordering a report by doing an analysis of their individual financial means. The evidence about the anticipated fees of the report also take into account the cost of calling the evaluator to testify at trial. In Alberta, the court will only order a report if the parties are able to pay its costs or if the applicant can pay for the report in the first instance, subject to seeking contribution from the other party after the report has been concluded. And on the slide, you'll see that we also recommend enhancing the availability of publicly funded reports. And if the current model of private pay continues, drawing on the frameworks identified in other jurisdictions, there's a possibility of regulating costs and refraining from ordering the reports altogether unless the court is satisfied that parties are able to pay based on their individual financial circumstances. And finally, we recommend exploring a possibility of a hybrid payment, which would be partially publicly funded and part payment by the parties themselves. I'll turn it over to Magal to discuss our fourth and final theme.
Thank you so much. So next slide, please. So this would be the slide titled Theme 4 Recommendations, Judicial Gatekeeping and Oversight. Okay, so for our last theme, judicial gatekeeping and oversight, we have a few subtopics that I'll talk about. And basically where this comes from is that training for assessors, experience for assessors, practice standards, they're only one side of the equation because children and families are impacted by actual practices. And actual practices in turn depend on judicial gatekeeping and oversight to ensure that requirements are adhered to, and the ability of judges, parties, and lawyers to identify and address problematic assessment practices. We recommend that this occurs throughout the process, from the initial determination about whether to have a report at all, if so, by who, and all the way to dealing with problems in the report after it's prepared. And as I'll explain, dealing with problems basically at the end, when there's already a prepared report, is the most challenging things to do. So the more safeguards we can have upfront, so basically in terms of training requirements, experience requirements, etc., practice standards requirements, etc., the more of those that we can have upfront, the better. So to start with the first recommendation that we have under judicial gatekeeping and oversight, which is when to order a report. So BC currently has no legislation on when to order a report. So the only principles that we have are based on case law, which is fairly limited as well, because a lot of these decisions are made in chambers. So there's no reported decisions that we can all refer to. However, there are a few decisions. There's even a fairly recent Court of Appeal decision from 2024, so after the publication of our report, but it confirmed that the threshold for ordering a report is low, and courts are encouraged to take a broad and generous approach to these reports and basically assume that these reports are almost always beneficial and helpful for the court. The Court of Appeal also stated that generally speaking, not always, but generally speaking, the only legitimate countervailing concern would be the cost of the report. And as with everything in parenting issues, the overall consideration is the best interest of the child. So in BC, the situation that we have, in our view, is fairly limited safeguards, and at the same time, a low threshold for when reports are ordered. Reports are not ordered automatically, but generally speaking, a party who opposes an application for a report would face an uphill battle. Some of our respondents in our interviews pointed out that there should actually be compelling reasons for ordering the reports, and not just ordering them as a matter of course and assuming that they would be helpful. What our interviewees recommended was that consider when they might actually be helpful, and when there might be other other avenues for presenting necessary evidence. So one jurisdiction that we compared the situation with was New Zealand, which actually has a fairly high threshold for when parenting assessments are going to be ordered. And one of the requirements in their legislation, the Care of Children Act, is the necessity of the report, and considering whether there are other avenues for obtaining the evidence that the court needs. So our recommendation on that topic is to enact provisions that specify when the court may order a report and the factors that the court should consider in its decision. And this is again to have clarity and consistency, and actually a robust inquiry into the need for a report. Next slide, please. So the second issue that we deal with under judicial gatekeeping oversight is selecting an assessor. So as I've mentioned earlier, we do have the practical challenge of a small number of assessors. In terms of the selection process, how it's done. So when the assessor is going to be a family justice counselor, they're assigned by court services, so the parties don't select them. However, when it comes to privately paid assessors, which is very common, so for example, registered psychologists, essentially the parties can agree on who to appoint, and if they don't agree, then one of them would likely make a court application and the judge will decide who is going to be the assessor. But BC has no formal rules or well-developed case law on how to select an assessor when the parties disagree. A contested application is possible, but it definitely adds to the costs. It's already very expensive to litigate. It can be inefficient. It can also undermine the confidence of the party who sort of loses in the assessor and the fairness of the selection. Some of the feedback that we received in our interviews was to clearly delineate what this expert is supposed to provide an opinion about and select the assessor based on that. So basically the best fit between the skills, expertise of the assessor and the issues that the case raises. And the expert should confine their opinion to the questions that they were appointed to address. Assuming that obviously in order to have clearer standards on how to select an assessor, we would need to have mandatory training and experience requirements. And then the court can ascertain that the assessor has fulfilled all of the initial and ongoing training and any experience requirements. As I mentioned earlier, when the report is supposed to address specific issues, for example, a child with special needs or addictions or substance misuse, etc., we also recommend that the court would inquire into the assessor's training and experience in those issues specifically, including the currency and breadth of their training and experience, and refrains from assuming that a certain degree or professional designation or just limited coursework is sufficient. In terms of some examples, so we have noted New Zealand, we've noted Ohio, we've noted California. Each of those has specific mechanisms for the court to ascertain the training, basically compliance with the training and experience requirements, and some ways to, and as well as lists of assessors that the court has to approve and can select from. Next slide, please. The next issue, which is very challenging to tackle, is admissibility. So I talked at the beginning about criteria for admissibility in general of expert reports and how the practice in BC is very different when it comes to Section 211 reports. After a lot of consideration, we determined that it was beyond the scope of our report to thoroughly analyze and make recommendations about admissibility. It's a very complex area. But we do encourage a shift from viewing the assessors as the eyes and ears of the court. So this is a viewpoint that was articulated by a court decision years ago and that still continues to this day, which again is an assumption that, which again makes assumptions about the breadth of the inquiry that the assessor can do, as well as about impartiality, objectivity, etc., and have a more qualified view that recognizes the potential problems in reports. Also, in terms of admissibility, another recommendation that we have is that if practice standards are enacted, then compliance with those standards would be required to admit the report into evidence. This is an example from California. So California, under their court rules, have very extensive training, experience, and practice standards requirements. And their legislation specifically states that unless the report complies with those practice standards, it would not be admissible. So this is something to definitely give serious consideration for. Next slide, please. The next one is ability to challenge the report. Again, a very, very tricky one, which is why we think that the more safeguards we have from the start and not necessarily, and from the start are so important, because when we get to this point where there's problems with the reports, it becomes extremely challenging to challenge the report. So ability to challenge the report is an important safeguard that many of our respondents identified. In BC and in the other jurisdictions that we looked at, there are very limited ways to challenge the findings and recommendations of the report. In BC, basically, if a party wants to challenge anything in the report, they have to call the expert to be cross-examined at the trial, which obviously presents significant barriers. One is cost that Gina talked about. The other one is expertise. So cross-examining in general is probably one of the most challenging aspects, one of the most challenging things that a litigator has to do when they're at trial. And the challenges are compounded when you're cross-examining an expert on their specialty, because if you don't have the specialized knowledge yourself or someone to guide you about this specialized knowledge, then you can't really cross-examine someone effectively. My practice and the practice of many lawyers is that when we have to cross-examine an expert, we actually consult with a different expert so that they would guide us through how to construct our cross-examination. However, you can imagine how much cost is added to that process. So basically, calling the expert to be cross-examined, paying your lawyer to prepare for cross-examination, paying for another expert to consult, all of this is pretty much inaccessible to most people. Now, in BC and other jurisdictions, there's also the possibility of obtaining another report, which is called a review report. Sometimes it's called colloquially a critique report. So basically, this is a report from another expert that's prepared for the party who is seeking to challenge the Section 211 report. The party who wants to obtain that has to pay for it. And there are very serious limitations on what these reports can cover, because the author only reviews the Section 211 report and doesn't conduct their own independent inquiry. In BC, we don't have any legislation about when a review report is admissible, but we do have case law that essentially says that review reports would only rarely be admissible. What this means in practice is that a party can obtain a review report, incur the cost of doing that, but take the risk that ultimately a judge would exclude that from the evidence. So basically, you would have wasted money for nothing. Our respondents in the interviews that we did recommended that this strict rule be relaxed and that review reports be more readily admissible. We did note the example of another jurisdiction in Alberta that have some a greater ability to have review reports admitted into evidence. We also found some other mechanisms in other jurisdictions, for example, in Ontario, where it's common to have disclosure meetings. And this is when this is an opportunity for the assessor and the parties to discuss the report and note potential problems. However, this is not a replacement for the ability to challenge the report in court, and the options for that are quite limited and expensive. The last one that we have under judicial gatekeeping and oversight is addressing safety concerns. This is again like a very tricky area. So basically, the issue is when the assessor is concerned that the contents of the report might put a party or a child at risk. And whether the assessor would have any mechanism or avenue to alert the court to that and try to navigate safety before releasing the report to the party about whom there are concerns. This can be problematic in various ways, but BC currently doesn't have any specific mechanisms for that. And we do recognize that a recommendation like that could entail procedural unfairness issues and other challenges, but it's still worthwhile to consider. A jurisdiction example that we have is New Zealand, where the court either on an alert from the assessor or on its own initiative can delay or make some orders about how the release of the report would take place to the party about whom there are safety concerns. So, sorry, I think I might have, I hope I didn't forget to ask for the next slide. The slide that I was just talking about was titled Addressing Safety Concerns. And if I could have the slide after that, please. So just to summarize, before we can hopefully go into some Q&As. So the first thing that I wanted to talk about is how our report might be useful to you, whatever your area of practices. So some of the things that we've done that might be of use are we have a review of legislation and framework in a number of other jurisdictions. If you're interested in doing a comparison or in seeing just what other jurisdictions are doing, what might be helpful in your jurisdiction. So we looked at some aspects of the frameworks in California, in Ohio, in Australia, in New Zealand, Ontario, and Alberta. Another aspect of our report that might be of help potentially is our literature review. So we looked at quite a lot of articles, summarized them. We have all the citations and everything. So if you want to if this could be a good starting point or an additional point just to look at some of the summary of some of the research that's available. We also have at the end of our report an appendix that summarizes British Columbia case law, where the recommendations or conclusions of the reports were rejected by the judge and problems that judges have identified in reports. So this, again, could be useful depending on your line of work, whether you're an assessor, whether you're a lawyer, to see what problems have surfaced and in our jurisdiction. And of course, we have the contributions of our focus groups and our interviewees who very eloquently put together and expressed various concerns that they have experienced in the course of their work. And we have some very experienced people there. So if you're interested in reading what they had to say, please read our report. So as I mentioned earlier, all the safeguards, all the themes, they're all interrelated. I have to say that like no jurisdiction really has a perfect framework, but in BC at least, because we don't have much, we also have the opportunity to learn a lot from other jurisdictions and see what other jurisdictions are doing and see basically piece together, hopefully, a framework that draws on the best in each jurisdiction and integrate them into a new framework. It's also really critical to pay attention to how a legislative framework about parenting assessments operates or would operate in practice. So basically, this is a big issue, but it's just a small part of the much bigger framework of the family justice system in general, with all of its various issues, whether it's funding, resources, accessibility, safety, etc. So it's always important to pay attention to how all of this fits together and how different parts of the system interact, sometimes for the better, sometimes for the worse with each other. So thank you so much for attending, for listening, and we're happy to take questions.
Yes. If I may first, before turning it over to Sarah for that, I want to thank both of you for your excellent webinar presentation. It was amazing. And I thought both the report and how you were making meaning of it were very comprehensively presented. I was especially impressed with how you provide this, what I call the contextual surround, by bringing into bear in your discussion the key issues, analyses, and recommendations, while also clearly setting out what needs to be done in practice at every stage of the parenting assessment process to assure this access to justice safeguards in those assessments. So yes, I do have a question myself, but I turn it over to Sarah in order to present some questions from the Q&A. Thank you again. Perfect.
Thank you both so much, and thank you, Margaret. So we have a number of questions that have come in, and I'll try to pick a few that we can really get to today, and then if questions continue to rise, hopefully people can reach out directly to you. One of the questions that we have from one of the attendees is, do you have some examples of Indigenous issues that need to be considered in assessments?
Yeah, I could try, and Magal, feel free to chime in. I think there's a number of historical and systemic factors when assessing Indigenous families. The role of extended family and community in raising children can be a huge part of the landscape in Indigenous family systems, which might be different from the sort of nuclear family model that we tend to default to in more of a Western conception of family law and family systems. Trauma-informed assessment practices are obviously very important for parties who have experienced systemic injustices. Trauma, displacement, and loss of identity may impact parenting styles and family dynamics. And I think being aware of certain laws that might affect Indigenous subjects of these assessments, the Act respecting First Nations, Inuit, and Métis children, youth, and families, aside from obviously the Family Law Act. Anything you want to add, Magal?
No, thank you.
Sure.
Thank you.
Thank you. I have another question for you, Gina, coming from Ruth. Ruth asks, Gina commented on psychometric testing. What is your opinion about psychologically sophisticated abusers who are able to manipulate the MMPI? Also, opposing counsel's tendency to manipulate the outcome against the victim/survivor. What are your thoughts on forensic testing?
I think those are valid concerns, and that's part of the reason why psychometric testing is controversial. Another reason for the need for specialized training that Magal identified in her comments. The second part about opposing counsel, could you repeat that?
Absolutely. The second portion of the question was opposing counsel's tendency to manipulate the outcome against the victim or survivor.
I'm not sure, sort of, it depends, I think, on the case and the recommendations that are made. But I guess that's why we have the, the adversarial court process where each side's lawyer is going to do their best to undermine the evidence of the other side or to achieve the favorable outcome they're looking for. Maybe from practice, Magal, you might have more to say on that, but...
Yeah, for sure. There is quite a lot of literature and actually quite a lively debate that we refer to in our report about the appropriateness of psychological testing generally. So there's quite a lively disagreement between various assessors. And one of them is Robert Simon, and my apologies, my brain is totally blanking out on the name of the other one, but I'll do my best to try to find it before the webinar ends, and if not, just send it to Sarah. So a few problems with psychological testing. First of all, the populations in which they're normed. So psychological testing were not created really for the purpose of family law disputes, for family law, for parenting issues. They were created for clinical purposes. So the initial populations in which they're normed are clinical populations, as opposed to populations who are of people who are engaged in family law disputes in court. Some research, and again, I'm a lawyer, so this is not my expertise. So this is all from, talking to psychologists, reading about it, etc. But there has research has shown that the testing results for populations who are involved, like it's called custodial litigants, is quite different from what it is for the general, I guess, clinical population. One of the problems that it can be seen like sporadically in various cases is which norms which norms are used to interpret the report. So basically, my understanding is that the reports are the assessors administer the testing, and then they have to interpret the results. But if the interpretation is not based on custodial parent norms, then the results can be quite skewed and misleading. Another problem that we see in reports is that the test results are just put out there in their report, but without really an analysis of how they fit, right, within the other parts of the assessment and why they're actually there, like what are they actually adding to the report. And the result of that can be quite inflammatory because as I think it was Ruth mentioned in her question, like it's really easy to pull out some statements from the discussion about the test, but without context and without an explanation of the expert about how this is actually relevant, it can be quite damaging. From my experience in reading court decisions, to be honest, I haven't seen that judges pay that much attention to the psychological testing, which again raises a whole different question of like, what are they doing there? Like, what purpose do they serve? They might serve a purpose for the assessor, but that needs to be clearly explained in their report, including any potential limitation of the testing. And research has also shown, I think, as Gina mentioned, that experiences of abuse, experiences of trauma can definitely affect the way that can definitely affect the results. Some tests contain sort of like, I guess, safeguards against that, in that some of the questions are designed, some of the scales are designed to assess where the person is at. But again, this is not something that's often thoroughly investigated. And just to mention, like, again, from a lawyer's perspective, and I'm sorry, I'm probably going a bit beyond what the question was about, but maybe it's helpful. The other part is the opacity of the testing results. So when a registered psychologist, for example, administers the testing, they cannot then disclose the raw data to another person unless it's also someone who is licensed to use that test. So that means that when we have these psychological testing results, as lawyers, as judges, we cannot really test them ourselves. We can't do anything about them because we don't have the raw data. We are not allowed to have it. And even if we had it, we wouldn't really know what to do about it. So this adds really opacity and like inability to scrutinize evidence properly. So when you have test results, as a lawyer, what I would recommend to my clients, and I have, is, okay, we need to hire another registered psychologist, for example, to receive the raw data, basically reinterpret the test and tell me if there are any problems in that. But this raises an issue of access to justice in that most people just don't have the money to do that. So I'm sorry, this was kind of like a long answer to a very complex issue, but I hope that to some extent, at least part of what I said was answered your question.
That was excellent. Thank you. We have a more BC specific question coming from Deborah that asks, have amendments to the Federal Divorce Act in March of 2021 impacted how judicial decisions and Section 211 reports are now being received?
So the Divorce Act doesn't deal with expert reports. It doesn't deal with parenting assessments. So the amendments also didn't touch on that specifically. One really good thing that came out of the amendments is much clearer and better, I think, criteria for looking at the best interests of the children, and also having some really useful provisions about very litigious topics, such as relocation, for example, which disproportionately go to court and also correspondingly also result in parenting assessments. So all of these are helpful, particularly if the assessor is knowledgeable about them, and can actually make recommendations that are practical in light of the legislative regime. But they haven't, I can't say that the amendments have like expressly impacted parenting assessment. Hopefully the amendments, the ongoing FLA modernization project will have some drastic changes, but we're staying tuned for that.
Absolutely. Thank you. And a question on the practical front, keeping in mind, I know, Margaret, you do have a question you want to ask before we wrap up as well, is can you provide a typical process for a voice of the child report?
Sorry, a typical process for a voice of the child report?
Yes. Yeah.
Okay. So one of the issues that come up in these reports is the terminology. So we have a lot of terminology. It's very confusing. People use the same term and mean completely different things. So instead of asking the person who asked the question, like, what do they mean exactly? I'll just explain it a little bit. So we have voice of the child report. We have views of the child report. We also call them sometimes evaluative and non-evaluative. So in a non-evaluative report is not a Section 211 report at all. All it means is that the child meets with a professional, someone who was trained to interview children. The interviewer asks some questions, the child answers, and the interviewer basically puts it into a report. This is what I asked, this is what the child said. This is not a Section 211 report or an expert report at all. The so-called evaluative one can be done under Section 211 of the FLA, and similar things can be done in other jurisdictions. And this is when the scope of the report is narrower, so you don't evaluate the parents as well. You're just mainly speaking with the child. And again, there's questions the child answers, and there's a report that talks about what was asked, what was said. But there's also an evaluative component in the sense that the assessor also looks at, is it possible that the child was coached? Did the child seem comfortable? What the child said, does it correspond to their presumed age and stage of development? Does the child understand the implications of what they're saying? So, and various other questions. So this is where the more evaluative component part comes in, and this is why it's a Section 211 report. The process for either of those, other than the differences in what the content of the report are going to be, ideally the child would be, again, this comes back to like influences on the child, etc. So different assessors might have different protocols for that. So it might be that the assessor would want someone neutral to bring the child to the meeting, just to maybe to counteract any potential last-minute influences. Or sometimes it's possible that the assessor would basically meet with the child twice, with each parent bringing the child. So practices may vary. I've also seen some views of the child report, again, like the evaluative ones, where the assessor also briefly spoke with each parent and incorporated what the parent said into their report. But it didn't include an evaluation of the parent, just more as a background. So practices may vary, but at the end of the day, we're talking about speaking, interviewing the child, putting a report, and like the content will depend on the type of report that's been commissioned. And I hope that answers the question. But if the person who asked wants to put in something else in the chat and just let me know if I answered it or not, then feel free to do that.
That was an excellent answer. Thank you. And we're running very close to the end of time, so I'll wrap up the Q&A and say thank you to you both so much for such thoughtful answers and again for such a great presentation. Margaret, back over to you.
Yes, indeed. So yes, I'll keep mine short here too. So thank you very, very much. I did have a question, but I can somehow get it to you. I had 3 questions, never mind. And be interested in how you would respond to that. But I also want to acknowledge and thank the interpreters, Violaine and Alexa, who did a great job, and Jade from UWO, very helpful tech assistance. as well as the UWO CREVAC Center itself, which has Katrina Scott at its helm. And finally, last but not least, certainly, Sarah Yursich, who did a superb job of stick handling and support throughout. So thanks to you all, and have a good rest of your day. Thanks again very much. Superb.
Thank you so much. It was a pleasure to be here. Thank you for inviting us.
Yes, thank you, everyone.
Thank you. Okay, off we go.